Nobody really likes to think about a situation where they may have an injury or an illness and they're not able to really manage things for themselves anymore. It's really difficult to face a circumstance where you may have to give up control to somebody else to make decisions, even somebody as close as a spouse or a child. But the reality is that it's not necessarily uncommon for any of us to be challenged with that, either by dealing with it with a parent or in our own circumstance, maybe facing a diagnosis or situation that we have to plan. There are really two documents that are critical to doing that. A power of attorney basically addresses the financial decision-making that a person has when we're not able to take care of business for ourselves. It's generally very broad. It involves day-to-day bill paying, maybe having telephone access or account access to a banker or an insurance company. It's documents that are nowadays necessary because the business world is very concerned about privacy. It's almost impossible to be able to help somebody else take care of a business transaction without having something in writing in advance, giving authority for somebody to take care of those things, even if they're routine things. What's interesting about, at least to me, with regard to powers of attorney is there are multiple types, but the two primary general powers of attorney, which basically cover all kinds of financial transactions, can be immediate or what we refer to as springing. An immediate power of attorney is one, once signed, gives access to the agent that we designate to be able to take care of business transactions and have access to information immediately upon signing. The other type, springing, requires that before it activates the authority or the powers to somebody else, requires a certification, a diagnosis from a medical provider, at least one, sometimes two, depending upon how it's drafted, that capacity or the ability to be able to manage things has gotten to a point where it's really not feasible any longer. There are different schools of thought. Some attorneys take the idea that all powers of attorney should be immediate, that we shouldn't be giving authority to anybody unless we already trust them and believe them. So there's no reason that we should have to go to a doctor and get some kind of certification as to incapacity in order for it to be activated. Other attorneys subscribe to the view that, and this is really where I sit most of the time, regardless of how much we trust or love somebody, it's not always the best idea to give control to somebody else to make decisions unless we are really at a point in our life where we're not able to do that for ourselves. Sometimes that's a challenge because it does require that a person contact a medical provider and get some kind of certification to activate those documents. But at least for me, I think for most of my clients, it's important that we maintain control of decisions as long as possible. Advanced healthcare directives are kind of a mirror image of a power of attorney. They deal with medical decisions, as the name would imply. A lot of people call that a living will. That's kind of an older term that is really not used in the professional capacity much anymore because it's confused with a living trust. But a healthcare directive basically gives somebody the authority to make healthcare decisions, and it is often thought of in terms of a life or death decision. Once somebody has a situation where maybe they're in a coma, it's irreversible, or a terminal illness or something like that, the question becomes, do they want to remain on life support systems and prolong life as long as is possible, or would they rather pursue a more natural death and not remain on life support systems? It's a little bit difficult for attorneys to be very specific in those kinds of documents because we're not medical practitioners. Medical science is a rapidly changing world. It would almost be impossible to draft something that could keep up with medical science. So really what it is, it's a statement when we're dealing with a life or death decision about what a person's wishes or desires are in the event that they find themselves in that situation. But ultimately, it gives the decision authority to the agent that they're designating to basically consult with medical practitioners at the time or moment when they're faced with that circumstance, so they can take in all the available information from the doctors and then consider the wishes of the person who is in that situation in order to make the decision that is in line with what those wishes are. It's not a direct statement, I want this in this situation or I want that in that situation, because it would be impossible to do that. And the other misconception with regard to advanced healthcare directives is that most people think of it in terms of only a life or death kind of circumstance, when in fact it is much broader than that. It could involve something that is routine. It could involve somebody perhaps who needs a minor surgical procedure, but maybe doesn't have the capacity to give consent to a medical provider, or day-to-day medical care. Taking a family member to a medical provider and being able to have open and direct communication with doctors about routine care. So it's a very broad document. It is really necessary to make sure that those things are in place in advance, because if a person reaches a point, even through accident, where it's unexpected, and they're not able to make those choices, the only remedy to deal with designating somebody to have that authority is to end up in court in a request for a conservatorship order. A very expensive process, somewhat lengthy process. It can involve a minimum of 3 to 4 months. The court requires an investigation, because we're dealing with something pretty serious when we're asking or seeking an order for somebody's own personal liberties or freedoms to be given to somebody else in order to make decisions. So we have to make sure the legal system, the judicial process has to make sure that the rights of everybody is protected and that we're doing something that is really in the best interest of the person who needs help or care. So it's really important that those things be done in advance. Conservatorship cases are a minimum of $5,000 to $8,000 in legal fees, so plus court costs and investigation fees and things like that. So it can add up to a lot of money, and it can result in family conflict if there's a disagreement about how those things should be addressed. So having those things planned in advance helps our family members be able to reconcile any disagreement so that they're not at odds with each other in court, perhaps damaging relationships irreparably in some circumstances.